Hello and welcome. My name is Ian Helms, and I'll be I'll be your host for today's event, Riding the Shifting Tides of Immigration in 2018, presented by Envoy. I am the content strategist here at Envoy, playing a key role in conceptualizing and developing all of our resources from educational webinars like this one. So thank you all for joining us here today, as well as visa guides, checklists, blog posts, emails, social media, you name it. I do all of this to keep individuals like you up to date on the latest immigration trends, news, and policy updates, and to help you better understand and navigate the immigration process. First, a few housekeeping items. This session is being recorded, and we'll be sure to send you the recorded session for your reference or to share with others in your organization within 24 hours after the presentation. Today's presentation is expected to last about 45 minutes or so, with some time left at the end for questions. To ask those questions, please use the questions function on the right-hand side of your webinar screen. One more thing before we get started, a little background about us here at Envoy. We are the leading immigration services provider, combining expert legal representation with technology to provide the only enterprise platform that enables companies to effortlessly hire and manage their workforce across borders. That's everything from navigating U.S. immigration to securing global work authorization and business visas to tracking and managing all of your international employees. We do that for more than 1,000 companies across many industries, locations, and company sizes. Without further ado, I'd like to introduce our speaker today, Allison Kranz. She's an immigration solutions partner here at Envoy. And prior to joining, she practiced immigration law as managing attorney at Manning & Gordon and as an associate attorney at Ogletree Deakins. In those roles, she gained significant experience handling all aspects of corporate employment-based immigration law and created strategies to address visa, work, permit, permanent immigration, and citizenship goals of her clients. She's represented Fortune 500 companies in business immigration matters and acquired critical experience in H1B LTNO and permanent resident cases, as well as U.S. Department of Labor audits. Her immigration law practice emphasized the representation of universities, in addition to the information technology, financial, national security, and healthcare fields. Excited to have you here, Allison, and have you join us to provide a comprehensive rundown of the latest immigration news and policy updates relevant to all of the folks at the organizations who are joining us today.
Thanks, Ian. I appreciate that. And, thank you for that awesome intro there. But despite all that good news and information and that long intro of me, I'm not here to give you legal advice today. Every single immigration case is different. So as we're going through the different information that we're going to discuss today, before you're certain that this applies to your employee's case or your individual case, check in with your attorney who's actually working on your case. Little minute details can dramatically change the outcome of a case. So we're going to talk about things generally today, but if you think something that we're talking about affects you, make sure that you're getting that information that you need from the right source, okay? Wonderful, wonderful. Okay, so today, quick overview of our agenda. We're going to go back to civics class a little bit and just talk about the federal government and do a review of the three branches of government to give you some context of other things we're going to be talking about today. We're going to review the government shutdown. If it happens again, what can we expect? We're going to talk about some of the trends and concerns that we're having for 2018. We're going to talk about how to identify impacted employees and plan accordingly. We're going to discuss some other changes that we should watch for, and then we're going to talk about overall recommendations. No one likes change, no one likes uncertainty, so I'm mentioning this because if you're on the call today, you're probably in a role where you're dealing with people's lives, employment, livelihoods, possibly their families, and when we're all dealing with subjects that are so near and dear to our heart, we want predictability, right? That's what we all want. We want that as professionals, we want that as individuals in our lives. And I feel like the things that I'm talking about today might be perceived as a bit negative because nobody likes change and uncertainty, but I really want to assure you it's not as dramatic and drastic as it looks, okay? So things that we're going to be talking about are proposals, and proposals are just that, proposals for the most part. And the law is the law. And really, obviously, for something to be a law, it requires an act of Congress. So we have a very vocal president, and we have very vocal branches, departments within the executive branches that are proposing lots of change. But even in the past, just because something's a proposal doesn't necessarily mean it's going to come into effect. So we're going to be talking about lots of potential change here today, but that doesn't necessarily mean that things should happen. So what does that mean for us right now? Well, we want to get the right tools in order. We want to line up the right resources now and be proactive. And if possible, come up with a plan B or plan C for potentially impacted individuals. So we're not in a situation later where our employees or us as individuals are feeling panicked and stressed out later. Okay. So I'm going to take you back to civics class or my favorite Schoolhouse Rock episode, I'm just a bill, yes, I'm only a bill, and just do some, bring you back to that place where we're going to quickly just look at this. And what we're seeing right now is a test of how far does the president's executive powers reach. Okay, that's what we're seeing across the board in immigration. Okay, and so just to remind you, a bill is proposed in Congress. Congress has to pass that bill through both houses, and then it has to be signed by a president. And then once that all happens, right, that bill becomes a law. And then that law is supposed to be an expression of Congress's intent, what they say is the law of the land, the rule of the land. And then it's the executive's job, the executive branch's job to interpret Congress's intent and try to implement what the law is supposed to do. Okay, and this happens using the executive powers of the president to implement, and the branches or the different departments under the executive branch, under the president. So most often in our situation right here, that would be the Department of Homeland Security. Okay, and in using those executive powers, how far is too far? Okay, how far can the president go before the executive branch is going above and beyond, outside of what that initial law intended? Okay, and that's what we're seeing, a lot of back and forth. And if you remember, when the executive branch goes too far, above and beyond what Congress intended, it is the job of the courts, the judiciary, to pull that situation back, okay, and give the executive branch its limits. So we saw this a little bit in January 2017, if you remember. President Trump's administration issued a travel ban, or some called it the Muslim ban, in the beginning for the first batch of that first proposal that came out. There was quite a few lawsuits that came out saying, no, this goes beyond the president's powers. The proposals, the executive order was redrafted. We had round 2, we had round 3, we had the courts push back at different levels, and really it's still going on at this point. So, you probably haven't been following that too closely just because there's been a lot of different versions, but that is a good example of something that I expect you're going to be seeing in the near future. I think that's going to be continuing. So, again, mention this because a lot of things are proposals, but just because they're proposals, it doesn't mean that they're necessarily going to go into effect. The government shutdown. We had a 3-day government shutdown, and a temporary spending bill was passed. And right now, since it was a temporary spending bill, negotiations are remaining active right now. Okay, so we have the Democrats and the Republicans facing off again for round 2. And there's a possibility of another potential shutdown. Hopefully that won't happen, but if it does, what can we expect? So although most of the government shutdown happened over the weekend, it didn't really affect a lot of different services where we can make strong predictions about what would happen going forward. But what we do know is this, okay? So in regards to USCIS, because USCIS is a fee-funded agency, USCIS should move forward with their normal operations. However, USCIS is also over E-Verify, and it was reported that parts of E-Verify were not working during the shutdown. Like I said, since it was over a weekend, we're not exactly sure what that would look like. I suspect that if over the next day or two, we'll learn more information about that, as well as if we're facing that situation again, USCIS is expected to provide more information up front about what parts of that would be functioning and what would not. CBP, is considered essential, so most business should continue as normal. Purely administrative positions could be impacted, so there might be some delays in processing of certain applications filed at the border crossings. So this is mostly going to affect Canadians, but generally speaking, there still should be officers on post in those departments. ICE is also considered essential, so business as normal should continue if you have anyone who's dealing with ICE because of removals or in need of certain special type of documents issued through ICE under kind of unusual or non-normal circumstances. Department of State is over consulates abroad, so visas and passport operations are fee-funded, and the processing of these applications should continue as normal. However, here's kind of the caveat in that, okay? Most consulates are housed within U.S. embassies, and U.S. embassies can be impacted, okay, because they're not necessarily funded by fees. So, depending on the personnel in different consulates across the world, some of these offices should continue business as normal, while others actually might be impacted, not necessarily because the personnel working on the consulate side are impacted, but perhaps the individual who you check in with normally who functions on behalf of the U.S. Embassy and the consulate is not going to be there to check you in, so the processing cannot continue forward. So if you have appointments, you should go ahead and you should inquire before anyone travels to any particular consulate to make sure that that interview or appointment is going to be honored if the government shuts down again. Department of Labor, all processing in regards to any immigration-related matter is expected to be on hold, as all personnel would not be able to return to work. And that's also going to include electronic web-based systems used for filing certain immigration-related applications. That's also expected to be on hold if there's another government shutdown. But I'm going to be an optimist, and I'm going to say that there won't be a government shutdown. I'm going to be hopeful, and we're going to hope for the best there, and that these two parties can get together and get some compromises that are good for the country. Okay. I should mention, I know I'm going through a lot of this information rather quickly, and we are going to have these slides available for you after the presentation. I'm going through it quickly because there's a lot to go through, and we have a limited amount of time. Also, because a lot of these things are not certain to happen, they're hypothetical. If something does happen, if we do have information that says this will happen, of course we'll have more information for you then, and we might even have emergency webinars, but definitely instructions and statements throughout our information center and through our website. So realize I'm going through this quickly, but wanted to kind of give you an overview of the different things that we're looking at for this year. In regards to concerns for this upcoming years and some thoughts and some trends we're seeing, there's overall increased scrutiny, and that's because a lot of officers have really been empowered to ask extra questions that were perhaps viewed as overly burdensome before, or discouraged for, and they were discouraged so officers can get through the processing of applications faster. Okay, because again, they have certain requirements that they need to meet in terms of how many applications they've processed over a period of time. Okay, but even though there's overall increased scrutiny that we're seeing across the board, please don't be intimidated by that. Okay, a good case is a good case. Extra government questions isn't going to change that, because if you have a solid case, you have a strong case, government officers can ask all the questions that they want. Okay, I understand that can be an extra headache. That can cause extra stress and anxiety for the foreign national, but a good case is a good case. And for most of these different visa statuses, they were created through law. And law gives us that predictability and certainty. And so extra questions is not going to change that. So please don't let that intimidate you. Now, in addition to that, we're also seeing that a lot of processing times have been increasing due to new requirements, and also because of this increased search scrutiny, right? Extra questions results in more time, but also because of new requirements such as the mandatory adjustment of status interviews or the green card interviews that employees are now having to attend for the 45s. And to respond to that, we have USCIS has actually gone and actually opened up a process for a lot of new immigration officers to be hired. Okay, so interviews are still going on across the country right now, and a lot of people have been hired. It's my understanding that generally the training period for those officers can range, depending what their positions are, from anywhere from 3 to 8 months. That's not official information I have. That's just my understanding of the process from speaking to people who have gone through that process. So we'll see a backlog until all those different officers are trained fully in their positions and taking on cases independently. That's what we're predicting. We've also seen an increase in requests for evidence, RFEs, and NOIDs, which are notice of intent to deny a particular case. And it's expected that those will continue for a period of time until officers get other directions other than to increase scrutiny on these cases. We've also seen a lack of predictability and arbitrariness in particular decision making. Okay, so to some extent this has always existed. Over my career, there's been a number of times that I've started relationships with new clients and I've said, listen, I want to gain your trust and I want you to trust me, but I'm sharing this with you up front and I want you to know at some point we're going to work together and we're going to have a good case that's going to be denied. And the reason why we're going to have a good case be denied is because officers have a lot of power to be subjective. And, you know, literally there's been times where I have filed 2 identical cases and one has been approved and one has been denied. Now that happens rarely, but it's happened before. And what attorneys are reporting over the past year is that they've seen an increase in that. Now, when that happens, employers and foreign nationals have different options, whether that's to ask for motion to reopen the particular case, or in some other cases appeal, or you know, even file applications to a federal court challenging decisions. Okay, but sometimes the fastest and least expensive option is just to file that case over. And so that's an important decision that you would want to discuss with your attorney. Again, we haven't seen a lot of these types of situations, but just an increase from what we've seen and considered as normal. We've also seen, you know, RFEs and denials being issued in routine cases. Again, that's what I mentioned, those easy cases, and some animosity towards foreign nationals. This is some of the things you might have heard in the news where individuals are coming in through the airports and being subjected to secondary inspection and you know, having their cell phones searched, or things that are kind of different than what's happened in the past. We've also seen judicial challenges, okay, such as the travel ban that was initially implemented last winter, as well as the judicial challenges to the DACA program that are currently ongoing. We have also seen official memos, official changes made by the Department of Homeland Security that they have empowered officers and changed prior guidance where previously, if you're in a situation where there was an extension application that being put in, if the first application was approved, everything was clear, there's no problems there, and no material facts have changed in the case, then we could count on an approval for that extension. And that's not necessarily the case. Now, officers have been guided that they can subject those extension cases to extra scrutiny. What that means is it's going to more impact your attorney for the most part, and maybe provide, your attorney might be asking for some extra documentation. Oftentimes, in my experience, attorneys would put a lot of information for that first initial case and maybe a little bit less for the extension. Chances are your attorney is going to want to put just as much information to support your petition for the second extension as well as they did on that first initial application. Some other concerns, and we're going to talk about this in more detail, is that there's proposals of terminations of certain programs, and then there's been announcements of terminations of certain immigration programs that allow for work authorization for certain foreign national populations. Also concerns the added uncertainty, stress, anxiety on foreign national employees, their families, and all of you that work with this population. Like I said, there's things that we can do here. We can be proactive. We can monitor these proposed changes closely. We're going to seek guidance from our Immigration Council whenever we have questions. We're going to use technology that allows us to quickly identify which foreign national employees might be impacted by these prospective changes. And please, please, please stay off the immigration blogs for your legal advice. It's just going to cause you a headache, and a lot of time that information out there isn't so great when it's one well-meaning individual without a legal degree giving you advice about what should or shouldn't be done. Sometimes those quick answers are not the best answers and just end up causing more trouble than necessary. So we want to be empathetic to the people that we're working with. We want to take their concerns seriously. We want to be transparent whenever possible with our company's goals and let people know that we value their work, we value their role with our organization, and we're going to advocate on behalf of them as much as we can within what the law allows. Okay, so going into some of the rumors and information, good and bad information that's been coming out lately. Something that has popped up in the last couple of weeks is the Trump administration is ending the ability to extend H-1B visas beyond the 6-year period. Okay, this is actually not true. Okay, from the information that is available right now, a couple news sources were reporting this, and shortly after, we actually had USCIS state very openly that this is not something they're actually considering doing. So that's some good news there. But even if they were, the ability to extend an H-1B visa beyond 6 years was created through Congress, and Congress allowed the Department of Homeland Security Secretary to impact some of the ways that an H-1B can be extended beyond 6 years, but not all of the ways. So even if USCIS wanted to do this, it wouldn't end all immigrants' ability to extend their H-1B visas beyond that 6-year period. The most they could do is just some of the ways would be impacted. So that is not true. There's also another claim out there that the term specialty occupation may be changing. This is potentially true. So in December 2017, Department of Homeland Security gave notice that it intends to propose and revise the term specialty occupation and employer-employee relationships to include focus on obtaining the best and brightest foreign nationals and better protect U.S. workers. What does that mean? We are not sure. We do not know. Literally not that much information other than what I've put right there was actually provided. So what they did, this information came from the Federal Register in December, and part of that notice was that a proposal would be out and released in October 2018. So we'll be looking for that, to how those things might be changing. But again, it's just a proposal. Just because it's published there doesn't necessarily mean it's actually going to come out. But that's what we know at this point, and we'll keep watching that for you. Okay. There is a claim that a bill in Congress would make it harder for some employers to place H-1B employees at third-party outside work sites. And this one is potentially true. Okay, so there is a bill in Congress, and it would subject H-1B dependent employers to more stringent compliance obligations and regulations. And it would be essentially more hoops to jump through before you're able to place an employee at a third-party outside work site. Okay. It would also change the definition of H-1B dependency from 15% H-1B workers in a workforce to 20%. It would also impose a recruitment report requirement for each LCA. Okay, so that's something, a recruitment report. We know that term from the PERM process, where we have to keep recruitment reports when we're sponsoring people for green card. Would that be similar? We're not sure right now. What would exactly that look like? Or are we just using that same term but in a very different way? We're not sure yet. But essentially, this recruitment report would summarize the employer's good faith efforts to actually first recruit a U.S. worker. And some exemptions would apply to that. Also, the bill requires the Department of Labor to investigate at least 5% of employers at random. However, this is just a bill in Congress. It's currently morphing and changing as we speak. And it's really too soon to tell what that might look like and whether it will actually be passed into law at this point. Obviously, immigration is a very politically hot topic, and things are changing very, very quickly. So quickly, in fact, Today, a new bill was introduced, and it was introduced by Utah Republican Congressional member Warren Hatch. And interesting enough, it's being called the I-squared immigration bill, okay, for immigration innovation, or I-squared. And this is really interesting. So this was released today. This came out today. And this new bill is proposing to expand the H-1B numbers from the current status of 85,000 to 195,000 H-1Bs issued per year, which is great news for employers. It has bipartisan support, and I guess it would be prioritizing graduates who came to the United States to get a master's degree in STEM fields. So that's the science, technology, engineering, math fields. So we'll be watching that closely. We'll be watching how that's received and how that moves. So it seems to have a lot of support, a lot of excitement about that today, and we'll keep watching that. There's also another part of that is going to impact some of the other things I'm going to talk about today, so when we get to that point, I'll mention those there, okay? Another claim that is out there is that the H-1B lottery system might be changing, and this is potentially true, okay? So again, in the Federal Register, and the Department of Homeland Security gave notice last December that it intends to announce plans to institute a registration process for the H-1B lottery. So right now, as we know, how the lottery works is you work with your attorney to put an H-1B application together. Most of us submit it to USCIS, where it arrives on April 1st, and then USCIS randomly chooses some applications at random and sends the ones that are not chosen, the whole package, just back to the employer. Okay, and what is being proposed is that essentially some type of pre-registration process would happen first electronically, and from there, only those people who are chosen in this electronic lottery would be able to actually apply on April 1st. We have very little information about this at this time also. What I have here in quotes, this regulation would help streamline the process for administering the H-1B cap process and to ensure that H-1B visas are awarded to the most skilled and highest paid petition beneficiaries. This is the information we have. This is the notice that was put out at this point. Very little information beyond this. However, the notice does reference a 2011 Obama initiative to create a pre-registration process that was similar. So we can go back and we can look at what that process looked like, and what it looked like is what I mentioned before, is that people would go and somehow register electronically prior to April 1st, and only those people who were chosen in that first electronic lottery would actually be able to apply on April 1st for the H-1B lottery. But that's the information we have right now, and more details on this are scheduled to be published in February 2018. So we'll be definitely watching that very, very closely, and letting you know what more information we have on that when it does come out. Okay, another claim that is potentially true, and most likely seems like it probably will happen. The ability of H-4 visa holders to get work authorization might end. This is true, okay, and this has been talked about in detail. This is more than a proposal. A notice has actually been issued that the Department of Homeland Security does plan to put a stop to H-4 visa holders' ability to get work authorization. And so, as many people know, not all people on H-4 status, the dependents of H-1B holders, can get work authorization, but certain people who are at certain points in the green card process are eligible. And, you know, in December 2017, we were given notice that it's reviewing this rule in light of President Trump's Buy American and Hire American executive order. Since that point, you know, informally, USCIS and officers within Department of Homeland Security have given interviews to different media sources saying that they're working on ending and rollback of this program. So right now we know that more than 100,000 people have employment authorization through the H-4 program, and this is going to primarily impact families from India and China. So if you have individuals who will be affected by this, if you have employees on H-4 status, please speak with your legal counsel so we can, your legal counsel can work with you to provide you with alternatives for these people. It might be having these people put into the H-1B lottery this year. There might be alternative possibilities, but it's something that you'll want to go and look at. Again, this is not something that, it's not a program that has been terminated at this point. This is not something that we have an end date on at this point, but from all the sources out there and the continued discussion, it most likely looks like it probably will be ending, unfortunately. The good news on this, the silver lining perhaps, in today's I-squared bill introduced by Warren Hatch, the I-squared bill actually would allow H-4 workers to continue, well, H-4 dependents, excuse me, to continue to maintain their work status in the United States and work legally. So if that bill does go through, that would be an alternative solution for these people, and they would be able to keep their work authorization. So that information's out today. We're sure the bill is going to morph a number of times before it goes up for any votes, but definitely good news for those individuals. The TN visa. Okay, the TN visa through the NAFTA program is ending. Okay, and right now this is not true. Now, currently the U.S., Mexico, and Canada are going through round 7 of negotiations for NAFTA. That's quite a bit of negotiating going on today. Now, if you have individuals on TN visas, might be worth it to talk to your attorney and see if it makes sense to put any of these people in the H-1B lottery just as a backup plan. Doesn't mean that TN visa status is ending, and quite frankly, even if the NAFTA program ended, that doesn't necessarily mean that the TN status has to end immediately. Again, there's some other possibilities for that, but we just don't have much information with that at this point. But round 7, these countries are still talking, which is a great thing, and we're going to hope that there's no change on that. But at this point, there's no reason to believe that the TN status would end. There's another claim that some of the categories in the TN program are changing, and this is partially true, partially false. Right now there's been an announcement that one particular profession in the occupation list is changing how it's going to be received and implemented, and that is for economists. Okay, so the economist category is not going to be permitted to be, I guess, interpreted as widely as it has been in the past. So people who are financial analysts, market research or analysis, market specialists, occupations, as well as other occupations related to economics aren't going to be permitted to be included in that. So, if you are an economist on a TN visa and you are a pure economist and not something related to an economist, you're still going to be fine. You're still going to be allowed to keep that TN visa with your status. But if you, if you have a little bit more of an alternative or related category of economists working for you right now, chances are they might be impacted by this. So speak with your immigration counsel by that. Also, as people are going through different processing at the airports, if they're Canadians, at the consulate, if they're Mexican, as they're going in and out of the country, they might be subject to different grounds of scrutiny here, okay? Especially as officers at the borders aren't necessarily the best at making technical decisions like this, at least in my personal experience, just because in the past they haven't been asked to make these types of decisions. You'll want to make sure that people are prepared when they're traveling, they have the documents that they need, they are confident in the way that they can answer questions, because in my experience, hiccups can happen when foreign nationals are unprepared. Even when you have a great case, if someone feels uncertain or unclear about what they're being asked, they might not answer that question in the most appropriate way, just out of nervousness. So we want to make sure that we're preparing people properly so we have people being able to travel with confidence. Okay, the DACA program. Going to go through DACA quickly. We have a couple slides on DACA and TPS, but we're going to go through them quickly because, just because we're with TPS and DACA, we're talking about over 1 million people, so I'm sure it's going to impact some of you. But since most of you are working for corporations and companies, I know it's probably not a primary concern, but just wanted to give you some background on this. So DACA stands for Deferred Action for Childhood Arrivals Program, and it was inspired by the DREAM Act, which was actually first proposed through G.W. Bush and Obama administrations, but failed to get through Congress. Because Congress could not find a way for these individuals who were brought here to the country by their parents as minors to obtain some type of legal status, President Obama, through executive order, created DACA, which essentially is a registration program. Essentially, the purpose and benefit is, and the rationale behind it is that the U.S. only has a limited amount of money to deport people for. Let's create a registry program so we know who's here in the country illegally. Let's give these certain people who fit the certain criteria the ability to work and remain in the United States. It does not make them legal. It just gives them the ability to work and remain in the United States while devoting the resources we have for deportation and enforcement of laws to people who might be more dangerous or violent offenders or criminals. So that's kind of the rationale there with the DACA program. It's temporary. It requires regular re-registration. So if someone is not complying with the terms of the DACA program, they might not be able to get that renewed and potentially end up in deportation or removal proceedings. Okay. And the current state of DACA is complicated. It's changing on a weekly basis. So just to give you a little bit of background, so Department of Homeland Security rescinded the DACA program in September 2017. And foreign nationals that have work authorizations, EAD, could keep working until that work authorization, their EAD, expired, but no extensions after that. The University of California and a variety of states sued, saying that the way that this DACA program was ending was improper, and had another couple claims along in their lawsuits with that. A federal judge agreed with part of what the states and the University of California was asking, saying, listen, there's a lot of issues to decide right here, but in the meantime, while the courts are going to hear these different issues, we're going to require that USCIS continues to process the extensions of DACA for these foreign nationals, because it's not clear that this program is going to end until this court, the court case is actually decided in full. Okay, and obviously stopping people's ability to work in the United States is pretty extreme in the meantime. So the federal court judge out in California in the Ninth Circuit did agree that in the meantime, USCIS should keep processing applications. And this just happened in early January. In the meantime, last week actually, the Department of Justice actually appealed to the Ninth Circuit Court of Appeals and then filed writ for the Supreme Court to actually hear the case. So essentially what they did is they filed an appeal to the Ninth Circuit, okay, but they essentially also applied to the Supreme Court almost for like a fast track hearing. Okay, so we're going to skip over the Court of Appeals, go straight to the Supreme Court, because no matter what the Court of Appeals decides, you know the losing party is going to appeal to the Supreme Court. So they're asking the Supreme Court to hear the case directly, skip over the Court of Appeals, and the Supreme Court this week did actually agree to hear the case. Now, in their appeals to these two different courts, surprisingly, the Department of Justice did not ask that the courts ask USCIS to stop extending the DACA applications in the meantime while the courts are hearing this argument. So that means that USCIS will continue to renew DACA applications while this case is being heard. Based on the current schedule of the Supreme Court, it's most likely that arguments for this case will be heard in spring. We expect applications to be continuing through probably late spring at the earliest that they would be terminated if they are terminated. But we'll keep out an eye for that, and we'll keep watching for that. Now, TPS, all right? TPS stands for Temporary Protected Status. It was established by Congress in 1990, and essentially TPS is intended to protect foreign nationals who are currently in the United States from having to return to their home country if while they were in the United States, their home country has become unsafe, and would put them at risk of violence, disease, or death. We saw this in Haiti after the earthquake, and certain countries have been affected by earthquakes, tsunamis, very political uprisings that makes the country very, very unstable, such as Syria and Yemen. And this status allows people to just remain in the United States, gives them work authorization, and be here until it's decided it's safe enough for them to return. And so a number of these programs were terminated. Okay, not all of these countries are terminated. So TPS is still available for some individuals. But here on the next slide, we see the countries where the program actually has been terminated. So we have Honduras, Nicaragua, Haiti, El Salvador, and Sudan all have been announced that the program will not be renewed. The program will be terminating as of these particular dates. Okay, and I provide this because really TPS is an area of immigration regulation that is not considered so partisan. It's bipartisan, depending on what type of situation or tragedy has happened abroad. Different presidents have allowed foreign nationals from those particular countries to stay in the United States for long periods of time. I have this slide here just to kind of show the impact of the estimated loss of individual work authorization. We're talking about quite a few people. We're talking about over 1 million people here who will be impacted. So I'm sure at least some of these individuals are working for your companies. Just because they are on DACA or TPS, and again, we don't know the fate of DACA, but I'm including DACA in here because it has the potential to terminate. Just because an individual is on TPS or DACA doesn't necessarily mean they don't have an alternative ability to get work authorization. Sometimes an attorney might choose DACA or TPS over an H1B or another status just because it's faster or it's less expensive or because there hasn't been a designated ending date, which allows for more predictability. So if you have an individual who has one of these statuses, again, get with your legal team to look at these individuals and see if there's an alternative for them. Now, this is a little bit tricky. I'm going to actually skip ahead for just a moment here. It's a little bit tricky on how we identify these people. So we're going to go back and we're going to talk about that because we're going to talk about OPT first, and then we're going to talk about how we identify these individuals because it's not as simple and easy as it might look, okay? So going back to where we were in the presentation, another thing that's changing is, well, I should say potentially changing, is some aspects of OPT. So after a student graduates in the United States, generally speaking, for a degree-seeking program, they get 1 year of OPT, or optional practical training in the United States. Now, President Obama extended OPT for people who had a STEM-based degree. They would be allowed to work in the United States, not just that first 1 year, but they would be given an additional 2 years, so a total of 3 years of OPT prior to having to leave or to switch to a different status in the United States. And so what is changing here is that, again, the DHS gave notice that is considering ending the extra 2-year STEM extension. And that's all we know, is that they gave notice that they're considering ending the STEM extension, and more information will be available in October 2018. Okay. All right, so for TPS, DACA, H-4s, OPT employees, what should we be doing right now? We should be making a list of people who are potentially impacted. We should be considering this April's H1B lottery if our legal counsel thinks that's a good choice. We should be, seeking advice on how to approach these individuals about their continued ability to work. It's really important that we don't assume that just because we have an impacted employee that they're going to be leaving their position. These employees might have an alternative way to keep their work authorization, like I mentioned before. We don't necessarily know. Perhaps that was chosen for a particular reason. Or that person could be in the process of getting a green card through family sponsorship, and perhaps it's never come up in discussions with you because, quite frankly, it's not something that they have to share. So we don't want to make assumptions. Okay. Also, when we're planning exit strategies, we want to keep in mind we want to inform recruiters of what positions will be open and when. And if someone doesn't have options and they will be falling out of status, any type of benefits that are owed or money that needs to be paid because of contracts, speak with your general counsel about when and how is the best way to pay these individuals, because ideally most companies are probably going to want to pay these individuals while they're still in legal status. But again, this is a conversation you should be having with your employment counsel and your general counsel about what the best thing to do for your company is. Because sometimes you might have to, change your policies in this circumstance. Also prepare for concerned coworkers. Be ready to address the politics. People have strong friendships with their coworkers, and it wouldn't be surprising if some people feel like this is there's anger, this is unjust, unfair. So be ready to have those conversations. Don't be shocked by it. Also, approach these situations empathetically, just so it doesn't make the work environment toxic or angry. It's a tough situation to be in. So how do we identify these people? We're going to look at the work authorization cards, the EAD cards here. Okay, and what we're going to do is we're going to look at the category here, the title, the subtext of category. It says C09 on this particular card right here. Okay, C09. That's the category we're looking at least that area. C09 is not actually one of the affected categories. They don't have a test TPS card or DACA card available on the government website. But this is what the card looks like, and we're looking for the categories A12, C19, C33, C03A, C03B, 303C, or C26. Okay, that's how we're going to identify these individuals. Okay, and I strongly recommend not to directly talk to these individuals prior to speaking with their general counsel or employment law attorney. These people could still be authorized for years to come. Work authorization is work authorization, period. Don't open up the door to accusations of discrimination unintentionally. So have that conversation about how we should be approaching these individuals, just so we can plan forward and look for option B or option C prior to going ahead and having those conversations with those individuals. We don't want to give them the wrong understanding of why we're asking, okay? We're running short on time here, so just want to mention a couple things quickly. Right now, if there's an emergency situation or something unusual, it's common for employers or attorneys to reach out to Congress to get additional support or help. Right now, USCIS is implementing additional changes for Congress to be able to intervene in cases. They want, for privacy concerns, they're saying they want to make sure that the congressional representative has the authorization to do this. So it looks like they're going to be asking for some paperwork to be done prior to providing information to that congressional representative. So that's something that's changing. Another couple things to look for. The ESTA registration program has been implemented in airports and seaports for quite some time, but it's now expanding to land and border crossings. So if you regularly have employees that are crossing the border from the U.S. and Mexico, Canada to the U.S., there might be some longer lines than usual in the near future. Also, the Visa Waiver Program is changing slightly, not so much for foreign nationals individually, but countries countries participating in that program are going to have to take certain steps in order to continue being part of that program. Also, there's some implications for pilots or other people connected to airlines. So if that's your business, reach out to your attorney on that to see what will impact you. Also, the Real ID Act went into effect on January 22nd. This involves not just foreign nationals, but U.S. citizens too, anyone traveling. So if your state driver's license isn't compliant with the Real ID Act, you're not going to be permitted to fly unless you've brought alternative acceptable identification. If you don't know if your state has Real ID Act compliant identification, check it out on these websites just to make sure that your foreign nationals and even your regular employees aren't surprised when they get to the airport and can't board their planes. Finally, some recommendations. A lot of them I've been mentioning throughout this presentation. Don't interact with immigration offices or officials without first speaking with your attorney or having an attorney present or being prepared for your appointment. Ask your employees to notify your office before they're traveling internationally. Prepare your employees and those who work with impacted employees for these types of changes or potential changes. We want to plan for longer processing times and unpredictability. We want people to understand that increase in RFEs does not necessarily mean an increase in denials. It just means extra questions are being asked. It's not necessarily such a horrible, scary thing. We also want to consider lobbying on behalf of our company, lobbying as an individual. If you are happy with these changes, let Congress and the White House know. If you're not happy with these proposed changes, let the White House and Congress know. Again, these are proposed changes. There are always periods of public comment as required by law. So we are the public, comment. That's how you can impact these things. It's really important that people jump in on this and lobby on behalf of the company or as an individual to let the White House as well as Congress know how this is going to impact them. If you get a response from your lobbying efforts, let us know. We'd love to share it with other professionals on the line today and the global immigration space generally. Remember, the law is the law, and the judicial branch is there to enforce the laws of the land. We also want to remember there's certain federal actions we might be able to take if we're unhappy with the decisions of the executive branch. And empathy and patience is key. We don't want to sweat the small stuff, and we're going to celebrate approvals. This can be hard, exhausting processes sometimes. Sometimes things go through easy. When we're in a situation where we're dealing with large populations of foreign nationals, it can be easy to go through the daily grind and forget about the individual impacts an approval has on someone's life. So, take a moment, choose to be joyful, celebrate those approvals. They're a big deal. But that's it for this point and right now, Ian. We want to come in and kind of wrap things up and see what kind of questions we have and explain to everyone how we can learn more.
Sure, Allison. Thank you so much for such a great and insightful presentation on what's happening and potentially happening in immigration right now. It was extremely insightful, and I hope everyone on the line also found it extremely informative. To Allison's point, if you're interested in learning more, it would be extremely remiss of me not to mention our blog. So don't forget to subscribe to our blog. We post regular updates surrounding the latest immigration news and policy updates. We have lots of educational resources there, and we also will be sharing our annual Immigration Trends Report. We actually have our 2018 Immigration Trends Report coming out in a couple weeks from now, so definitely subscribe in case you want to be among the first to see all of those things come out. We send a bi-monthly blog digest as well as a monthly newsletter if you're interested. So we do have a few questions coming in already, and if you do have other questions, as a reminder, please submit them on the right-hand side of your screen. So Allison, let's start with this one. You said OPT may be impacted. What about CPT?
Okay, so CPT stands for Curriculum Practical Training. So this is something often a student might have to work or have an internship or externship at an outside company as a requirement to graduate. Often engineering majors might have this type of requirement where they have to do like a semester at a company prior to being able to graduate. CPT, there's nothing out there that suggests that CPT would be impacted any way at all. So if you have students on CPT, there's nothing out there. There's no reason to have any concern about those programs.
Great. And to elaborate, if we have another question, can I sponsor an OPT employee for a green card, or do they need to get an H1B visa first?
So again, every situation is going to be different, and so depending on what country that individual is from and what the position is, the answer might change. However, generally speaking, if an individual is on OPT, they can be sponsored for a green card directly. There are some situations with, like I said, foreign nationals from certain countries involving priority dates, which would not make that possible for certain individuals. But there is no restriction on having an individual on OPT status next have a company sponsor them for a green card and then go directly to the green card.
Okay, great. And we actually have a lot of questions rolling in about H4s. If I have an H4 employee who is in the green card process, should I be putting them in the H1B visa lottery, or should I wait until they get their green cards?
That's really going to depend on where they are in that green card process. what country they're from, how they're eligible for that green card. Is it family sponsorship? Is it employee sponsorship? Is it through their spouse? Is it directly through your organization? Depending on the answers to those questions, your immigration attorney is going to recommend different strategies. So touch base with your legal counsel there.
Okay, great. And a handful on H-1Bs. It is H-1B cap subject visa season right now, so no surprise here. For some general information and a rundown, also head to our aforementioned resource library. We do have an H-1B visa cap survival guide available there, so don't forget to head to envoyglobal.com/blog to find information on that. But some of these more specific questions that we can answer on the call today: if the H-1B lottery changes, what information will be needed for the pre-registration process?
Ooh, we don't know that yet if it changes. That information is not out yet under the 2011 Obama era proposal. The information that came out wasn't simple. Okay, so it wasn't just name, position, company. It was being proposed as a number of pages of information describing the position being offered and the credentials of the individual to accept that position. So it's hard to tell. All we know is that it referenced that 2011 program. Would it require the same type of information? It's really too soon to tell at this point. But I would suspect, and what my gut says, is it would probably be, much of the basic H-1B information that you send right now for the H-1B program, without the nuances or some of the extra information that doesn't focus on the actual position. But that's just a guess. That's an estimate.
Okay, and this might also be a guess, but do you think the new H-1B lottery will go into effect this upcoming season?
I should have addressed this. Great question. Now, if you would have asked me this question a year ago, 1 year ago, I would have said there is no way that this new program could be implemented for this current upcoming lottery season. Okay, that's what I would have said. However, when the announcement came out that all individuals applying for green cards, all employees would have to attend interviews with USCIS officers prior to getting their green cards, and would go into effect on October 1st. I said there's no way they're going to have this done by October 1st. There's no way that they can get the offices organized that quickly. But I was wrong. They did. And because I was wrong about that one, I'm not going to gamble on this one. Technically, if you look at the required period of comment and the requirements necessary to actually implement change in the regulations, there is technically enough time to do it. There's very, very little time to do it. There's no room for error if they were to implement it this year. Technically, it's possible. I think it's probably not very probable that it'll go into effect this year, but it is possible. So we'll be watching that very, very closely and providing you information about that as soon as it comes out.
All right, perfect. And with that, we've reached the 2 o'clock hour. So I'd like to first thank you, Allison, for the great presentation again, and as well to all of our great attendees and the folks who join us every twice a month for all of our webinars. So again, a reminder, this presentation will be sent out within 24 hours. And if you are attending for HRCI or SHRM credit, we do have that information on this slide here. So thank you again for joining us, and we'll see you next time.